One.
Our next distinguished speaker is Amy Lawrence. Amy is an associate in the Privacy and Data Security Group at law firm Frankfurt, Kernet, Klein & Sells. Amy advises clients across industries in privacy and data security matters involving the collection, storage, and use of data. She works with clients to develop privacy, data security programs and policies, respond to data breaches and regulatory inquiries, and conduct privacy due diligence. Thank goodness for people like Amy, because we don't like doing that stuff. Her practice places her on the cutting edge of privacy and data security law, regularly advising on the EU GDPR and the CCPA that we're going to talk about a lot today to build appropriate compliance programs and procedures. Prior to joining Frankfurt Kernet, Amy worked as an associate with Morrison and Forster and Davis and Gilbert. That's a lot of names. There's no Smiths and nothing easy to pronounce necessarily. She also previously worked in traditional and digital advertising agencies before becoming an attorney, which I think really helps with today's presentation. So with no further ado, let me thank and welcome Amy Lawrence.
Hi, everyone. Thanks for having me. I am going to try and share my slides with you. Here we go.
I think you want to go to the slideshow menu at the top and then start from the beginning.
Sorry, I'm having difficulties.
Amy's based here in California.
Okay.
And then we have to do that display setting again, exactly.
Yes. How is that?
Perfecto, thank you.
Great, great. Thank you for bearing with me for a moment. So I'm going to go ahead and start to click through. So I'm going to talk with everyone about the California Consumer Privacy Act today. And I think that this is incredibly important for everyone in any organization because it's really a sea change in the way privacy law has been thought about in this country, and kind of following on the heels of GDPR and how that changed quite a bit in Europe. But this is our own GDPR moment in the United States, and we're really just getting into the tip of the iceberg. Today we're going to talk about, I know this looks like a lot, I talk fast, so you know, we can.
You know what? I think we still see your title screen. Is that where you are, Amy?
Oh no. Hold on.
This is always the way. We had it working perfectly before.
Flawless rehearsal. It may, since I still can't see anything on your end, help if you exit out and then try to just start over completely.
Okay, let me stop sharing and we'll try this again.
There we go.
How's this? Okay. And did that get me full screen?
No, you were full screen, and then whatever you just did, it went back to the 2 screens.
Oh no. And where I'm having difficulty is then I can't get back to whatever the...
Why don't you just leave it in this mode and go ahead and click on slide 3 because we could see it pretty well.
Yeah, that works.
Yeah.
That looks good.
Okay, that works for me. All right, so yeah, we're going to talk about the CCPA. I'll give you some of the background of it. There have been a lot of changes with the CCPA just in the past couple of months. The law was passed over a year ago now, but there have been recent amendments from the legislature and then some guidance from the Attorney General. We'll talk about all of that. But the big things here are that the definition of personal information and definitions of some other terms have changed dramatically. So in the United States, we used to talk about PII, and then in Europe, they started talking about personal data. And now in California, we're talking about personal information. And with those different terms come very different definitions. And so that's something that it's good to prick your ears up when you're hearing these different terms thrown around, that they're changing. So a little bit more of the background. So on the right here, we have Alistair McTaggart. And I think this story was actually from the New York Times. So thanks, Peter. And the background here is that in California, you don't actually need the legislature to pass a law. If you have a ballot initiative and you get enough signatures, it'll go on the ballot in November, and everyone in California can vote on whether it becomes state law. And the implications of that are that when a ballot initiative is passed, then you need a ballot initiative to make amendments to it. So it makes it much more difficult to change the law if it goes into place through the ballot process. So the way our story begins is that Alistair McTaggart made a fortune in real estate in the Silicon Valley area, and he became interested in privacy and made this his personal movement. He had a conversation with someone from Google, or one of the big 5 companies, and they said something to the effect of, "You won't believe how much information we have about you." And that really got him thinking about, well, how could I even find out how much information Google has about me or Facebook has about me? And in Europe, they were suddenly getting all these new rights where they can find out what information Google and Facebook and any other company has about you. They were getting these access rights, which we just don't have in the United States. So he wrote a law, and he wanted to get it on the ballot for November. He started collecting signatures. Things were going about as you would expect. Like, some people thought that he was a fringe lunatic. Privacy is always in the conversation in California. It's part of our Constitution, and so there were similar efforts in the past to get this kind of law on the books that never really moved forward. But this time, something happened in early 2018 that really helped him out. The Cambridge Analytica scandal hit, and everybody found out what Facebook was doing with their data behind the curtain, and nobody was happy about it. And suddenly it was a lot easier for Alistair McTaggart to gather signatures from people who thought there should be a privacy law so I can figure out what's going on with my data inside these big companies. So he very quickly reached the minimum number of signatures needed after that. And then the big companies started to get a little bit scared. And the legislature became aware that this was probably going to happen. The way that the law was summarized to go on the ballot, it talked about an individual having the right to know what a company knows about them. So just the way that it was phrased, everybody in the ecosystem was like, oh yeah, this is going to pass if it goes on the ballot. So what can we do to try and make sure that it can work going forward? So they got together with the legislature, and Alistair McTaggart agreed that if they passed a law that was similar to what his ballot initiative said, that he would drop the ballot initiative. And that's what happened. They all got together within a week's time. They took the law, they tried to clean it up, they convinced the governor to sign it, and suddenly there's a law that nobody really heard about until this California passed this historic privacy bill. So then people started reading it, and it was a mess. Okay. So it was signed into law in June of 2018 last year, had a ton of typos, had some conflicting areas of the law. It was something like 10,000 words. It's a very long and convoluted law. And so there were some efforts to clean that up. Everybody, in passing it really quickly, everyone in the legislature said, okay, we'll deal with it next session because we don't have time right now, but we can clean this up and make it a better law, which we can do because we're the legislature and it's not a ballot initiative, so this should make it easier. So that happened. They cleaned up some typos. They didn't get them all. There's still some typos in the law. But then the next legislative session, they started working on these amendments. And there were a lot of amendments proposed. There were amendments from specific industries. There were amendments that were, more directly dealing with labor or other public interests. There were a lot of them, and in the end, not a lot of them went through because there became an effort. It became bad PR. It became a thing where you were anti-privacy if you wanted to amend this law, which I don't think is true. I think that companies that wanted to fight specific areas of the law got a bad rap. Not to get down on the free press, but that there was an overarching narrative that you were somehow anti-privacy. If you wanted to change this law at all. So now we're getting really close. The law goes into effect January 1st, 2020, and enforcement by the Attorney General begins in July 2020, or 6 months after the AG issues final regulations. So those regulations have been released in draft form. They came out about a week and a half ago, and so we're in a public comment period. We can talk more about that later, but I don't think that this July 1st, 2020 date is going to move for when enforcement by the Attorney General begins. The bigger picture is that because the law goes into effect on January 1st, there's also a private right of action associated with the law, and that will take force January 1st as well. So you'll probably hear about class actions around the CCPA before you hear about Attorney General enforcement. Okay, so why do we care? The law applies to a lot of companies, and it applies to any entity that has an annual gross revenue in excess of $25 million, or if you annually receive information from 50,000 or more consumers or households. So this is the bullet point that is really going to catch a lot of companies because consumers include website visitors. So if you're getting more than 137 hits a day to your website, you're hitting this 50,000 threshold a year. And for any company that runs a digital subscription, that is probably exponentially higher than 137 visitors a day. So it should be on everyone's radar that you might get caught up in this law if you have any customers that come from California and you're hitting these low thresholds. The last one, if you derive 50% or more of your annual revenue from selling consumers' personal information, that one was really designed to catch data brokers. And so I see that one as more of a narrow catch-all for data brokers, but yeah, it would get you there if it didn't get you somewhere else. So what is a consumer? The way that the law was originally written, it was basically everyone in California, and it still is all California residents, regardless of location. This is tied to your tax residency. So I'm a California resident. If I go to New York and I am shopping in your store, reading your paper, on your website, I'm still a California resident, and so I am a consumer under this law, and I have its protections. The law applies online and offline, which is another big change for privacy law generally, at least as far as to this point in the United States, privacy law has been very sectoral. So there are a lot of financial privacy laws, there's a lot of health privacy laws, and then there are kids privacy laws. But this one applies to everyone. And when we see those laws, we see them much more online and not offline as well. So this gets you protection as a consumer for everything when you're surfing the web, you're a visitor, or if I go to a store and I hand them my credit card and they swipe it, I'm giving them personal information about myself. And so it covers me in both senses. And that's a new paradigm for companies in the United States to be working with, that your offline data and your stores of paperwork would be subject to someone saying, well, what do you have on me? And then you suddenly have to go back to your storeroom and try and figure out through your credit card receipts what information you have on this person.
Hey, Amy, just a question to clarify. When we think about the 25 million or 50,000 user thresholds, are those among California residents or in total?
So it is not clear from the law. Oh. I think that the way that this will be interpreted is that obviously if you have it in California, you're definitely in. If you have it and it's nationwide, then the question becomes, well, how do you know how many are in California and how many are outside of California? And if you have clear record keeping that says all of my consumers have billing addresses in Nevada and not California, then maybe you can make an argument. The other thing that I would say about that is that as far as your risk level is different depending on what happens. If you find yourself caught up in class action litigation, plaintiffs' attorneys aren't going to do that kind of due diligence before they file a lawsuit. The Attorney General probably will. The Attorney General will probably start asking questions about how many of your customers are in California, how many of your customers are elsewhere, to determine if you're subject to their jurisdictional enforcement. But if you end up talking to a plaintiff's attorney, you're probably going to have to defend yourself on this point. And so the more detail that you can put together to say, I don't meet these thresholds, the better.
Thank you.
Yeah. Okay, so like I said, there were amendments that passed. There were a lot of amendments that were proposed, but only a handful passed. And this is a partner that I work with a lot, wrote this article about not much changing in the CCPA. And I like this because of the dumpster fire visual, which is how a lot of us in the privacy world think of this law, is that it is a huge dumpster fire for a lot of companies, that there is so much that you have to deal with that you've never had to deal with before. And the timeline is really short now because the law goes into effect in just a couple of months. I think we're down like 70 days, something like that. So the actual amendments that were passed, the law was written much broader as far as consumers. So it uses the word consumer, but it was including employees, owners, directors, officers, staff members, contractors. All of those people became consumers under this law, which opens up a huge can of worms, for your internal record keeping purposes, that suddenly all of your employees have the right to access their entire personnel file under this California law. And so there were competing laws, even in California, having to do with your record keeping obligations, having to do with your other legal obligations for privilege, and in case of internal investigations. There are all these very thorny issues. So this amendment was proposed, but was met with a lot of resistance from labor unions, because, and I think that what it really boils down to is their concern is employee surveillance. And so this amendment passed. Employees are not going to be part of the CCPA consumer definition, but that amendment sunsets in 1 year unless they can reach another agreement with organized labor, basically. So you have some more time to figure out the employee issue, but you might only have another year to figure out the employee issue. Where the employees do still have rights under this law that are new is that the employees can still exercise their rights for their private civil action in the event of a data breach. And they also still have the right to know the information that you're collecting from them. So this is supposed to get to, if you have cameras on your employees and you know when they're coming and going, or if you're reading their key card swipes so that you're keeping track of where they are, that you would let your employee know. And so if you don't already have an employee privacy policy or an employee privacy notice, you're going to need one if you have California employees, because they, as of January 1st, have a very explicit right to know what information you're collecting about them. Okay, so business contacts are the other big area. So business contacts would have been pulled into the definition of consumer without this amendment, but similar situation, we get another year to work it out. The business contact, so basically everybody in your Outlook, everybody in your email file, who you're working with people in other organizations. That passing of an email address, of a first and last name, all of that would be personal information under this law. So this helps companies deal with the fact that they probably have a ton of that information that they're not really, keeping like an inventory of if somebody came over and asked to see what you have about them. So this gives, again, another year. The sunsets January 1st, 2021. And there's still specific rights that are available to your business contacts under this law, in particular the do not sell provision, which we'll get to in a little bit because it's complicated. So where we had amendments that there were exemptions without sunset, these are areas that get more to specific industries. And if you have specific questions, I'm happy to talk about them. But for the most part, these are medical information, financial information, and Credit Reporting Act covered information. The issue here is that, okay, so you have a company that processes financial information. They're going to tell you, or you'll say, if you are that company, that everything that you collect is subject to GLBA or the California version. The way that the law is written is there's some murkiness there. Like what you've collected that is actually pursuant to that law is for sure exempted. But if you're collecting any other information, IP addresses from people that visit your website, that's not collected pursuant to GLBA. So you might still have a CCPA issue on your hand just based on the other standard collection that you're doing from consumers if they visit your website, if they purchase your services, from their other interactions. Okay, so I talked a little bit about this already, but I want to make sure it's really clear that personal information is way broader than PII. So PII would cover your social security number, specific health information, specific financial information, credit card numbers, all of that. But personal information under this law is anything that identifies, relates to, describes, or is reasonably capable of being associated with, or could be linked directly or indirectly with a particular consumer or a household. So it's just about everything you can think of. If, female, I'm female, that's personal information to me. My address is also personal information to me, but then it's also personal information to my spouse and my kids. So, because that's our household information, it is very easy for this to spin and spin and spin so that a lot of data that your company is holding or processing or passing through is personal information under this law. And this is the reason why this is such a big deal, because it really changes your obligations to individuals who may be in California, who may be elsewhere, if you can't tell if they're in California or not. And it's a real sea change in the way that privacy is thought of in the United States, because suddenly a lot more information about me, the fact that I am a New York Times subscriber and that I read their the food articles more than the politics articles, like all of that information, the inferences about me, the things that I like, the things that I am more likely to click on, it's all personal information to me. So the way to deal with your personal information is you can always use it in a de-identified form or an aggregate form, but the de-identification standard under the CCPA is much higher than the national standard as well. So that's something to keep in mind if your tech guys are saying, oh, everything we do is de-identified, everything we do is anonymized, everything we do is pseudonymized. Start asking more specific questions about, well, what do you do? Do you meet the CCPA standard, or do you meet the FTC standard, or are you using a GDPR standard? The words have different meanings in different places, so you have to dig a little bit about what's actually happening. Okay, so service providers and third parties. This is another place where under GDPR, they very neatly categorize everyone into a controller or a processor. CCPA unhelpfully creates this third category. You can be the business, or you can be a service provider, or you can be a third party. And that opens us up to more complications, so that you can't just say, well, I became GDPR compliant, I have processor agreements with all these companies, so that should cover me here too. It's really not true, because a service provider, all the payment processors, the gateways that Peter talked about, those are probably all service providers. But the CCPA has very specific requirements about what goes into the contract with the service provider. and the use limitations that they can exercise on the data. So I know someone asked about having one of the service providers contact consumers before their credit card expired. And so I'm thinking about that from the CCPA perspective, and that would be a clear violation of a service provider contract, such that that party is no longer purely a service provider to you and they become a third party. And the implication of that is that your liability goes up if they do something wrong with the data. If a service provider does something wrong, you're probably fine. Like your liabilities are going to stop with you if the service provider does something that they're not permitted to do and you didn't know about it. But if a third party does something that they're not permitted to do and you didn't know about it, or you did know about it, it increases your own company's risk with what happens to that data. Excuse me. So the other definition here, business purpose, this is where if you're passing data to a service provider for a business purpose, then it is not a sale. And we're talking about sale in the CCPA context, which has a very, very broad meaning and includes almost every transfer of data. So if you are using a service provider, but the reasons that you're using them don't fall into these business purpose categories, then you might still have problems. So what are these business purposes? The CCPA breaks down business purposes or commercial purposes. Commercial purposes are basically anything that you're doing to make money. Business purposes are these specific categories where the legislator sort of acquiesces that you need to do these things, and you need personal information to do these things. So if you're counting ad impressions, you need, it's either cookie data or an IP address or something specific about the web browser and the user. So you need that information to count your impressions, to know, to verify that the ad is running, to show that that you're getting the eyeballs that you're paying for, or that you are being paid for. But also, security incidents, anything that you're doing to protect against fraud, all the log files that your company keeps, those are probably all for business purposes, because they are areas where you need personal information, but you need it for a very specified purpose, and you're not using it for other reasons, sort of willy-nilly lumping it into a data lake that is then used to create profiles on people or segments. And there are all sorts of things that the legislator is worried that is happening within companies. And as long as you're not crossing that bridge and you're just using the data for the things that you really need to make your business work, then you're fine. So what does this mean for consumers? And I'm sure a lot of people on this call are consumers in the CCPA sense, as well as people working at companies. And so you will have these rights as of January 1st. There is a disclosure and access right. So now you'll be able to reach out to a company and say, what information do you have on me? I want to know the specific pieces of information that you've collected. I want to know the categories of information that you have used and any information that you've shared for business purposes or for commercial purposes, or if that information has been sold. So you as the company, you're going to need to know, like, okay, I have Amy's data. It's been shared with the payment processor for business purpose. It's also been shared with an ad agency to build a segment so that I can reach people like Amy or reach Amy directly when she's on the Washington Post site instead of the New York Times site. Those are the commercial purposes where a sale of your information is implicated. But either way, you have to tell people, if they ask, what information you have about them and how you're using it. Consumers will also have a right to deletion. So if I come to you and whether I ask you what information you have about me or not, I can come to you and say, I want you to delete everything you have about me. And as a company, you have to do it. You have to, there are certain exceptions to deletion, information that you need to retain for a legal purpose, to comply with another law, because you need to retain payment information for fraud verification and for GLBA and any other law that at the federal level at least that you need to comply with. You can say, I can't delete your data because of that. But otherwise, if you don't have a legal reason to hold on to that data and I ask you to delete it, you've got to delete it. And we get a lot of questions. When counseling clients, a lot of companies ask, well, what do you mean delete? Do you mean really delete forever? And yes, I mean really delete forever. I mean take it off your server. You don't have to go into like archive data, but you have to take it out of use. You have to delete what you can. So the trouble with this from the business's point of view is that, well, how do I know you're really Amy when you come to me and you ask me to delete all of your information? And Amy has a subscription, and that's going to stop her subscription. That's going to stop the delivery. That's going to stop her access online. How do I know it's really you? Excuse me. So there is a verifiable consumer request process that you can go through. You can ask for more information to make sure that I'm Amy. And the Attorney General regulations that came out speak a little bit to this, although they don't provide incredibly specific guide rails for what to do. But the basic idea is that you have to think about the information that you collect, and then think about the information that you need from an individual to be able to match those together. If you can match me with an entire file on me just for my email address, then you really shouldn't be asking me for more than my email address. But if you really need, because you have 500 Amy Lawrences in your system, if you need more, you're allowed to ask me for more. And I will provide you with as much as I'm comfortable with, and you will respond in kind. If I refuse to provide you with more information, then you might not need to delete the information that I'm asking you to delete. It starts a conversation that I think that a lot of companies aren't really excited about having, because there's no clear-cut answers. There's nothing that says, well, I asked her for ID and she didn't provide it, so I'm not going to delete anything. It's not that clear-cut. It's more that you as a company need to provide a reasonable response. So if I ask you to delete, and you can, and it's not going to hurt the information that you might have about somebody else in my household, or about a service that I signed up for and didn't actually tell you to cancel, I'm just telling you to delete my information. So you have to put your reasonableness hat on and say, well, what makes sense from what this person is asking for.
So Amy, question for you. It's a little broad, so I apologize. When you're working with companies like us publishers, here at Tribune, it's our legal team and our data team who are really in the thick of it, and thank goodness for them. A lot of the people that are on this webinar are the marketers who are acquiring and retaining digital subscribers. What are the kinds of questions and concerns that you're hearing from people like us who are kind of hoping and trusting that our data and legal teams are on top of it, but what should we really be worried about and poking into in our conversations with those data and legal experts?
Yeah, so what I would say is that where you need to be keeping an eye on, where you need to be thinking about are, the marketing team works with a lot of vendors, and there may be a transfer of data between companies. And so anytime data is coming into your company, if it's from an individual or if it's from another company, or someone that doesn't have a direct relationship with a consumer, you need to know where is data coming in and where is data leaving. So if you are doing custom audiences, you are pushing segment data or email lists. If you're pushing data to another third party, then that might be a sale under the CCPA. And so this gets right into do not sell requests. A consumer can tell you to stop selling their data. And so internally, you'll need to think about your process for how do I take individuals out of the bucket of the data pool that I'm working in. And I know it's not necessarily front of mind with the people who are doing the marketing and the acquisition and just trying to bring it all together. But it's going to become, I think it's going to fall on those people to actually effectuate these requests. So the data team is going to give you a list and they're going to say, stop selling the data of these people. And you're going to have to reach out to all of your connections and figure out a way to communicate these consumer requests to all the other companies that you're working with, or internally if you're working with different departments, if you're working with other areas. You're going to need to work out these lines of communication for how to effectuate these requests. I think that's how it's going to hit the other, outside of legal and outside of IT. I think that's how it's going to hit inside a company, is that you're going to need to know, where does this person's data go once they subscribe? You're going to need to know how many different paths you need to go down when somebody says, delete my data, because there's an obligation on the company. If I say delete my data, then you also have to pass that down to your service providers so that they delete the data too. So you guys are going to be in the middle of all of that, if you, any relationships that you have with vendors, that's all going to come down on you if you're the point of contact.
Yep. So I think, to my colleagues on this call, I think one of the key takeaways for me is, now is the time to be as transparent as possible with our colleagues in the legal and data departments who are thinking about this day and night. This is not the time to conveniently forget about a vendor because you're too busy, because the liability is too great. And so I'm thinking about, for Tribune, what are the ways that we build custom audiences on Facebook or on Google? What are the ways that we do a dynamic paywall or churn modeling that might, use vendors for segmentation purposes? What are the ways that we leverage an email service provider to be able to deploy emails on our behalf? And, where are all the fail points or touch points that we have to consider as we think about what you're going over here?
Yeah.
And so, that kind of stuff is not just the data and the legal team's responsibility, it's everybody's. So I'm so glad you're here, Amy, walking us through this. I'm sorry to interrupt, please.
No, that's fine. And
I'll get off my soapbox now.
Yeah, especially if you have agreements with those vendors that don't go through legal, maybe push them to legal now. That you're gonna need some specific language, and maybe your legal department has a paragraph to add, if you're working from the vendor's paper. But a lot of vendors that you're going to be working with are going to be accessing, to some extent, personal information under this law. And so you want to protect the company, you want to protect yourself, as you don't want to be the break in the chain for data as it goes out the door. But yeah, to the extent that you have those contacts outside of the company, keep an eye on them.
Do we have to worry about first-party cookies, which we marketers might be using to be able to keep track of your meter, how many articles you've read in a given period of time, or to ease your login? So maybe you've saved your login for future access. Are those things we have to worry about too?
So I want to be careful here, because I know that first-party cookies means different things to different people. Okay. So first-party cookies that are your own company's cookies, that are performing an essential function, you don't have to worry about those because they're probably doing something that if they're collecting impressions, if they're a session, or if they're a cookie that helps you log in. You don't have to worry about those being there. What you will have to worry about is that, to the extent that people are clearing their cache every day because of concerns about cookie data out there for them, doing what you can to help consumers understand that these are the good cookies, that you want to keep them, to help them, this makes your experience better, but actually telling them, this is what saves your password, so you don't have to log in every time. That can be really helpful. To the extent that there are first-party cookies that are provided to you from other companies that are doing those same things, it's a little bit iffier. It's still likely that that company is a service provider and they're doing something strictly that is a business purpose. So Google Analytics is a good one there, where everybody has Google Analytics. It's providing analytics on your site. You really can't run a website without Google these days. And so that's another one where I'm not concerned about that, because I think that it's serving an essential function.
Great.
If you're using a first-party cookie to conduct retargeting of advertising on another site, that gets a little bit hairier. So now, it's a spectrum. And if you are using what you're calling a first-party cookie, but it's really provided from another company, and that is doing retargeting advertising on a site, that's where I think the line is, that you can't engage another company to do retargeting of advertising for you on other sites or across the web and call it a first-party cookie anymore. So that's the long answer.
No, I appreciate it.
The answer is most first-party cookies are okay.
Yep. So we've got 15 minutes left. I'm going to let you get back. If you have a question, feel free to put it in the Q&A. If you have a question that is eating away at you, but you're thinking, gee, I don't want Mark to say the name of my company because I feel like it's going to be embarrassing, you can privately chat me and send me the question, and I will not name who's asking. So it'll be like, a friend is asking, and we'll pose that to Amy. So get out the inner things in the next 15 minutes. So go for it, Amy.
Okay. So do not sell my information. This is where we really break from GDPR. These are completely new rights in the United States, completely new to anyone. This law requires that you have a link, a button on your website, a logo. It hasn't really been worked out yet what it'll look like or where it's supposed to go, but it's supposed to be a clear and conspicuous link, which, talk to your ad team about what clear and conspicuous is, and you'll get all sorts of answers. So basically, it's got to be a button on your page, though, that says, do not sell my personal information. And, the pushback on this is just, it's a tornado, because it's ugly. Nobody's going to understand what it means, because sell doesn't really mean sell in the way that people think that it means. And so you have to have it, though. The law says very explicitly, you have to have this link that says, do not sell my personal information. Whether there are constitutional challenges there, we'll probably see it, but for the time being, this is what the law says. So the consumer has the right to say, stop selling my information. And it has to be through a button on your website. If you don't have a website, you got to make it available in another way. But the most common thing is that it's going to be on your website. It's going to be on the home page, and it's going to be on every page that collects information from a California consumer. So selling means not just selling, it also means renting, disclosing, disseminating, making available, transferring, otherwise communicating for monetary or other valuable consideration. So monetary consideration is easy. If you are getting paid when you pass an email list to another party, that's a sale. Valuable consideration is much more nebulous, and ad tech is where it seems that they are trying to get to, because of Facebook and Cambridge Analytica, and because there are hundreds and hundreds of companies that you don't really know what they're doing with your data. It's this huge, the internet is a black box, and you only ever put information in and you never get anything back, except for all the free news that you get back and all the things that consumers don't really see as part of the exchange. But if I'm passing your IP address, then that's suddenly a sale. So how this affects the ad tech community is really interesting, and I could do a whole hour just talking about programmatic advertising and how I see this changing the world. But if any of you are members or even interested in the Interactive Advertising Bureau, they've put out some really good stuff on this, and they have this beautiful visual representation of what's a sale and when disclosure of your personal information might not be a sale. So if you are using a service provider, not a sale. If you are providing information to any other company, it's a third party, and that's going to be a sale under the law. So the IAB also, they've put together a framework, which is also still in draft form, even though we're very close to.
Yeah, they better hurry up.
They better hurry. I'm sure they would love to hurry up, but they have put together a framework that would allow passing of signals throughout the ecosystem, so that if you're using ad servers, DSPs, DMPs, all of those companies that don't have a direct relationship with the consumer when they come to your website, it really simplifies things for publishers, because okay, you have the link on your site that says do not sell my personal information, and if somebody clicks it, then it automatically passes through the ecosystem that signal that says this person doesn't want you to use their information beyond actually fulfilling this bid request or ad request. Like however you're setting up your, if you have an internal ad server, it can be the same way. If you are using an external ad server, it really simplifies the process. There are a couple other things that'll kind of fly through. Financial incentives. There are specific areas of the law that might be concerned for publishers, because they do speak to financial incentives, and you can't discriminate against consumers who have exercised their rights by refusing them services. So this implicates loyalty programs. It might implicate tiered subscriptions. It'll definitely implicate if you are doing differential subscription pricing. Things like that are things that hopefully your legal team is already thinking through. If you are coming up with new stuff in the marketing department, run it through your legal team, because financial incentives might be an issue under the law. The bigger implications. There's a private right of action under the CCPA. If you have a data breach, everyone in California is going to try and sue, and there are statutory damages under this law. The defense to this is that you have reasonable security in place, and reasonable security isn't defined in the law, but other California advice has been pointing to the CIS standards, so you can look to that as your backstop. And then there are proposed regulations. The Attorney General in the law was supposed to come out with more guidance for business on how to comply with the law. These came out October 10th. They added new requirements for notices that the business has to give to consumers, new timelines for complying with consumer requests. If you don't want to read the full 25 pages of proposed regulations, reach out to me. I have a summary that's much shorter that I can provide. It's a lot, and it's new stuff for a law that's going into effect in less than 3 months. The AG is holding hearings around the state in December. The regulations probably won't be final until sometime in January or later. The regulations are in an open comment period, and so this gets to encourage everyone to comment to the ways that CCPA isn't working for you or that you can make it better. The AG needs to hear that from businesses. And I understand the whole, I'm asking for a friend. Nobody wants to say, Attorney General, we won't be able to comply with this law, so you need to change it. That's obviously a non-starter, and that's not what I'm saying. But I think that to the extent that you can make, particularly in the news media, there's a lot of hesitancy to be anti-privacy or labeled anti-privacy in arguing against this law, and we've ended up with a narrative that has been all one-sided because smaller businesses haven't really come forward to say this is really unworkable and why. So enforcement by the Attorney General, I think I said, is later in the year. And so this is my warning. What I used to do, here's what you need to do now. You need to do your data mapping. You need to update your privacy policy. You need to, do all these things. And these days I'm in much more of a doomsday scenario mood. Yes, you need to do all those things, but you need to do them faster now. Because not only do we have the CCPA coming, Alistair McTaggart has gone back to the drawing board. He now has decided that CCPA is not enough, and that he has the ear of the voting, the voting people of California, that they are telling him push for more privacy rights. And so he has proposed a new law that is likely to be on the ballot in November 2020. Stay tuned, because if this goes through, it's going to get a lot worse, a lot more complicated. It's going to be a lot closer to GDPR in your like needing to opt in for, particularly for certain categories of information instead of opt out. With that, I'll also say, like, I get a lot of questions on federal privacy legislation, and I'm looking at, like, here is something that is written and probably going to be on the ballot in November. Do not hold your breath for federal privacy legislation or its preemptive effect. You're probably going to have to comply with California and several other states before we get a federal privacy law. So this is sort of like, I'm raising the alarm bells. The British are coming. This is the privacy law that you're going to need to deal with, even if you're not in California. It's a tsunami, and it's coming your way.
Got it. So now the downsides of California are earthquakes, CCPA, traffic. I think that's the new ranking.
Yeah.
You mentioned something that really perked my ear about differential pricing, which is, something that our print colleagues have been doing for some amount of time. Maybe digital are thinking about it. Can you just speak about that too? And yes, Matt, I did forget fires. So maybe it's like earthquake, fires, CCPA.
I would put fires higher than earthquakes at this point. I mean,
right.
Fires are a guarantee.
Okay.
Earthquakes.
Maybe we'll just say like natural, Mother Nature. Okay.
Yeah.
So yeah, tell us about differential pricing real quickly. What are we about?
So there's an anti-discrimination provision within the law. So with differential pricing, it can still be done. The CCPA doesn't necessarily say you can't do anything, but it just adds a lot of hoops to jump through to get there. So your terms and conditions have to be very clear to the consumer, what they're signing up for. And if they cancel, that's when it gets complicated. Like if they cancel, how are they going to be penalized, and is that clear when they sign up? So this is where your opt-in language has to be very clear on, like, you are receiving this rate because whatever, and because of it's a limited time only, or because you are, we see that you, whatever reason it is, you don't have to go into it, but you need to make it clear to the consumer what's actually happening. And if it really is based on their exchange of data, you need to make that clear how you've calculated that, which a lot of companies are doing now. That there's a data valuation. There are vendors that do this, and I know that, as particularly in the advertising world, there's a lot of data valuation happening. So if you have that information available, you can point to that. But it's really, like, that's an area where I would say make sure your legal's involved and that they are aware of what you're doing and how it works.
Great. Well, Amy, thank you so much. We're just about out of time. So there were about 6 questions that were left over from Pete's presentation that we didn't get to.
Yeah.
And so Pete has generously agreed to put together an email with some Q&A. So Pete, thank you in advance for that. And so if anybody has a question like lingering for Pete, you've got all of 2 minutes to put it into your Q&A box so that it gets into his email. So thanks again, everyone, for joining us for such valuable sessions. Obviously billing is so important to subscriber retention, and CCPA just affects everything. And so glad we could talk about it in the context of this subscriber retention session, but really with 70+ days to go, we ought to be talking about it in every session. Our next master class is in exactly 4 weeks. It's on Thursday, November 21st. That is 1 week before Thanksgiving. Joining us will be Alex Milne, who oversees the WSJ Plus membership program. I'm really excited to hear about that. And then closing us out for this series will be Curtis Huber, the Senior Audience Director from the Seattle Times, who's going to talk about culture. And I'm really excited about that because really that underpins everything that we do to make sure that we're all aligned and marching in the right direction with good goals. So until then, thanks so much for your time. Katie, as always, thank you for everything you do to help these sessions get off the ground. Amy, Pete, fantastic presentations. And I wish everybody to have a great rest of your day. Thank you.
Thanks, Mark. Take care.